If you're going to court in a child custody or family law case and there's an expert who's going to testify and you don't agree with that expert's recommendations or report, there's a way to discredit the expert. Watch this video for tips on how to successfully discredit an expert while they're being testified on the stand during an evidentiary hearing. My name is Wendy Hernandez, and I'm the creator of Command the Courtroom. I'm also a Phoenix family law attorney, and I've been practicing law since 1996. There's something I guaranteed on the Command the Courtroom YouTube channel for you if you're going through a family law case or a child custody case. Watch the videos. If you like them, please give them a thumbs up. Also, if you haven't already, subscribe to the Command the Courtroom YouTube channel. Go ahead and do that now. So let's dive into today's topic now. How do you discredit an expert witness who's on the stand with whom you don't agree? Step number one, you have to understand the expert witness's qualifications. So just like us, quote, normal people, experts also have resumes. They call their resumes something a little different. They call it a curriculum vitae. I'm not sure exactly how you say it, but it's a Latin term. And essentially, what it is, it's a summary of all the experts' education, their qualification, their experiences, any articles that they've written. And like us, quote, normal people, I've always been told to keep my resume limited to one page. It's not unusual to find an expert who has a CV or a resume that goes on for pages and pages and pages. You need to look at your expert's CV or resume. And the reason is because you need to make sure that that expert's qualifications are consistent with the topic on which the expert is opining or giving opinions on in your case. If your expert doesn't have any experience with child custody cases, yet they're doing a custody evaluation, that could be a problem. You also want to look at the types of articles that the expert has written and any academic journals the expert has contributed to. And it would be helpful, if you have the time, to check those articles out so you can understand more about the expert. If that expert doesn't have education and experience that is in line with the subject on which the expert's testifying, then potentially that's fertile ground for you to discredit the expert while the expert's on the stand. The next thing you should look at in deciding whether or how to discredit an expert in your case is the methodology of the expert. In order to understand whether the methodology of the expert was proper, the first thing you need to do is understand what the standard of practice is in your area. And that can vary from jurisdiction to jurisdiction, sometimes even from city to city. So you're gonna have to do some research, you're gonna have to ask around and find out what other experts in your area are doing when it comes to the particular type of evaluation we're talking about, whether it's a child custody evaluation or a business valuation in a family law case. So come up and understand the standard of practice in your area. Then take a look at your expert's report to make sure that they did their report or did their investigation consistent with the standards of practice. If they didn't, then again, that's a particular area where you could discredit the expert while the expert is on the stand. If that expert deviated from the standards in your locale, potentially that could be a problem. The third thing that you can do to discredit an expert who's about to testify in your family law case is determine whether or not that expert is biased in any way. So, in many cases, parties share the costs of valuations, whether those are child custody evaluations or business valuations. But there are many circumstances where one party or the other hires an expert and pays for that expert with their own money solely without contribution from the other party. These are cases where you can inquire of the expert while on the stand about the fact that one party paid for the expert's services. And I don't know how many judges buy into it, but the point is if you're paying an expert to testify, when you're paying an expert to do a report, is there a possibility that that expert is going to give an opinion that the person who's paying them wants them to give? Possibly. It's very possible. And so this issue of bias is something that you can bring up if the other party is paying all alone for that expert's advice and recommendations. I will tell you that most experts that I have talked to have said, I can't be bought and I am going to give my opinion, even if it doesn't support the person who's paying me. And I have seen reports and recommendations that actually don't support the person who paid the expert. So, and many times in those cases, the person who paid the expert's not too happy, but it has happened. So look for potential bias when it comes to who is paying for the expert. And another area in which to look for bias is, has the expert worked for the other party in the past, or does the expert know the other party in some way? Or if the other party has an attorney, does the attorney and the expert, do they have any kind of relationship? Have they worked together quite a bit in the past? These are things to look at, and you can work them into your cross examination of the expert as areas of potential bias. And you may or may not get somewhere, but it doesn't hurt. So if you're watching this video right now, I want to know why you're interested in this particular video. Do you have a case where there's an expert who has been appointed or who could testify in the future and you're worried about what the expert has to say? Drop me a comment below and let me know what has you interested about cross-examining experts in a family law case. So my next tip is probably my favorite way of discrediting any witness while on the stand, but especially an expert. And that is pointing out inconsistencies between the expert's testimony and what they actually wrote in their written report. And you can do this using some of the other methods that I've shared in Command the Courtroom videos on cross-examination. So if you haven't already checked out those videos, check them out. But what you're going to need to do is be really familiar with that expert's report. You're going to need to know it inside and out. You're going to need to know what the expert relied on, the basis for their recommendations and their conclusions that they're making. And you're going to need to know it really well, because if the expert gets up on the stand and says something different than what that expert wrote in the written report, you will need to go quickly to that part of the report to point out the inconsistency. Now, in situations where the report is not that long, this can be pretty easy to do. In other situations, though, I've seen experts who have reports that are a couple hundred pages long. That may not be so easy to do. And in that situation, I, as an attorney, would pick out the 5 biggest areas that I think hurt my case, where I think maybe the expert made a mistake, and I would really know those inside and out, and I would be ready to pounce on the expert if I think that the expert did something wrong and potentially the expert is going to backtrack while on the stand. Then I would be ready with those areas. I'd have them tabbed, I'd have them outlined, I'd have them blown up onto a chart so I could discredit the expert where that inconsistent testimony is being made. And another area which I haven't used so much is when an expert is reaching conclusions in your case that are different than the conclusions an expert has made in writing in the past. So, for example, if an expert has written an article for a journal or published something and is using reasoning that's different than the reasoning the expert's using in your case, or reaching conclusions that are different than the expert's using in your case, or using methodologies that are inconsistent than the ones being used in your case. Again, potentially, that is an area where you could discredit your expert. The bottom line is, if you're going to use this methodology, you really need to know your evidence. You need to know what the expert is relying upon, and you need to know the report. So you got to roll up the shirt sleeves and study the material, have it organized, have it tabbed in a way that you can easily find what you need to go to in the middle of trial. Because as you know, as I've talked about, when you're in trial, the minutes matter and you don't have a lot of time to be fumbling around with paper. So you have to go quickly to where you need to go. So this is the thing you have to remember with experts. The expert is the expert, and they're probably pretty smart if they've gone to school and they have some experience in the area that they're testifying about. So because an expert is the expert on a particular subject matter, it's not always that easy to discredit them on the subject matter because they're the expert. It's hard to argue with an expert. But one area where I think potentially you can get an expert while they're on the stand is if you can find an area that they missed. So, usually in a report and recommendation, the expert lists out the bases for the recommendation, and that includes all of the documentation that they reviewed, and the witnesses that they interviewed, and the tests that they did, and the analyses that they did. If you can find an area where the expert missed talking to a witness or missed reviewing a document, and the expert missing this particular piece of information really goes to the heart of your case, that can make an impact with the court. That can make a judge call into question the expert's credibility and the judge's reliance on the expert's expertise. So, again, this is another situation where you have to thoroughly understand one, what the expert looked at, and two, you have to understand what evidence exists in the case. And if the expert missed an important piece of information or evidence or didn't ask the question, that's where you can get the expert. You have to be prepared to bring this up at trial. And the time to prepare, again, is not at the trial. You prepare your cross examination of the expert before the trial. You know what the expert is going to testify to because it's probably going to be pretty consistent with their report. So you got to outline those areas where you're going to impeach the expert before your hearing and have the information that you're going to use to complete that impeachment available, ready to go at your finger. So the final area I'm going to talk about is the expert who really is not as familiar with your case as they should be. The expert who is making generalizations, the expert who is making recommendations based on stereotypes. And if you look at the report and you see areas where your expert is generalizing, or if that expert's on the stand and they are generalizing or saying in general XYZ, then that's where you can also impeach the expert because, as you know, each case is different, each party is different, each party's kids are different. So the court has to evaluate facts based on the facts of those cases, not in general. So if the expert is not making recommendations and not evaluating a case based on the specifics of your case, that's a problem. The expert should not and cannot be using generalizations. And if they are, then to me, it's a clue that they're not as familiar with the facts of your case as they should be. And that's where you can really start to question them as well and call into question their credibility. All right, so we just went over a bunch of tips for challenging the credibility of experts on the stand. Now, obviously, I'm just going over the ways in which you can challenge an expert's credibility. The exact method to impeach a witness is laid out in some of the other Command the Courtroom videos, which I mentioned earlier. So if you haven't checked those out, I would recommend that you check them out. If you like this video, be sure and give it a thumbs up. If you haven't subscribed already to the Command the Courtroom channel, please subscribe so you get notification each time there's a new video. Also, leave me a comment below and tell me if this video was helpful. Send an email. I love hearing from you. I may not respond to every single email that I receive, but I love getting your messages about what you're going through in your case, your challenges, your obstacles, and also your successes and your war stories. There's so many people having success with doing it on their own, and it is possible. One of my viewers just sent me an email the other day and said, if you stand on the truth and you prepare, you can do this. And I agree with him wholeheartedly. You can do this. So until next time, remember to keep on trucking and get out there and command the courtroom. I'll see you next time.